So friends, Special Counsel Jack Smith didn't just fire a shot across the bow, he fired a cannon across the bow regarding the way he is dealing with the Mike Pence subpoena issue. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, I want to touch on a recent legal development involving Special Counsel Jack Smith and the subpoena he served on the most cowardly politician in America, Mike Pence. Because this story really tells us a lot about the kind of prosecutor we have in Jack Smith. But it's not at all intuitive from the reporting. So let me start with the reporting, and then let's talk about why it tells us so much about the way Jack Smith is proceeding in his investigation of the crimes of Donald Trump. The story first broke in this CBS News article. Headline: Special Counsel asks judge to compel Mike Pence to testify in January 6 probe. And that story reads in part: federal prosecutors have asked the Chief Judge in Washington, D.C.'s federal court to compel former Vice President Mike Pence to comply with a grand jury subpoena and testify as a witness in Special Counsel Jack Smith's investigation into the events surrounding the January 6, 2021 attack on the Capitol. 3 people familiar with the investigation told CBS News. Filed less than 2 weeks after news broke that Pence had received the subpoena, the legal document asks the court to uphold the subpoena's legal authority and indicates Justice Department prosecutors are moving quickly in their attempt to get Pence before a grand jury. And friends, Jack Smith filed this motion asking Chief Judge Beryl Howell to shoot down, to deny Mike Pence's privileges before Mike Pence ever set foot in the grand jury and started to invoke those privileges. And I want to try to explain why that is so unusual, so important, and so telling. And hopefully, if I can explain it well enough, by the end of this video, you'll see why Jack Smith is like a Major League Baseball pitcher, and he is striking out batters while they're sitting in the dugout before they even have a chance to walk to home plate for their at-bat. So friends, we're going to start with a discussion of a legal doctrine known as ripeness, and then I'm going to move on to a real-world example of a witness going into the grand jury and pleading the Fifth, invoking their Fifth Amendment right against self-incrimination, a situation prosecutors deal with every day. I dealt with it hundreds of times in my former career as a prosecutor, and I want to use that to try to help explain why Jack Smith is really a different kind of federal prosecutor. But let's start with the doctrine of ripeness. What is ripeness? Well, let me give you the legal definition. A claim is ripe when the facts of the case have matured into an existing substantial controversy warranting judicial intervention. Clear as mud, right? Bunch of legal mumbo jumbo, written by lawyers, probably who were billing by the hour. Let me unravel what the doctrine of ripeness is by using a real-world example. Boiled down to its essence, a judge won't decide an issue until it's ripe, until it's ready to be decided, until both parties have sort of done everything necessary to bring the issue to a head so it can be presented to a judge, and a judge has an issue, a controversy that is well defined and that can then be decided by the judge. Let me use a real world example. Often I would subpoena people to testify before the grand jury. You know, for 22 of my 30 years, I was trying murder cases and RICO cases in Washington, D.C., so I often use homicide cases as an example. It's what I know. And I would subpoena people to the grand jury who I believed had relevant information and evidence about the murder I was investigating. So let's assume that I have a target of the investigation, somebody that the evidence suggests committed a murder, and I learn that the target's girlfriend is a witness to the murder, and I believe she can identify her boyfriend as the perpetrator, as the killer. We serve her with a subpoena. She comes down to the grand jury. Maybe she has counsel representing her as a witness. If she doesn't, before I put any witness in the federal grand jury, I always advise them they have a right to a lawyer to advise them as a witness before the grand jury in case, for example, they have a concern about a Fifth Amendment privilege against self-incrimination or other concerns. We can get a lawyer appointed free of charge to help them navigate their way through their grand jury appearance. So let's assume that this witness, together with her lawyer, tells me before we enter the grand jury, I'm going to plead the Fifth. I'm going to invoke my right against self-incrimination. Now, that strikes me as odd because I don't have any evidence that she has a Fifth Amendment right against self-incrimination. Because the only way you have that right is if your truthful testimony would incriminate you, not if it would incriminate your boyfriend or your loved one or a family member. You can't plead the Fifth for that, only if your truthful testimony would make it look like you committed a crime. So let's assume this witness said, I'm going to plead the Fifth. I don't want to testify. I'm not going to go in there and say anything. I say, okay. And then we go over to see the chief judge who has supervisory responsibility over the grand jury, including litigating privileges that witnesses try to claim. And I say, Judge, this witness said she's going to plead the Fifth in the grand jury. I don't think she has a Fifth Amendment right against self-incrimination. Based on the information I have, I would like you to order her to testify. You know what the judge would say to me? Well, Mr. Kirshner, has she testified yet? No, Your Honor. So she hasn't gone into the grand jury and pled the Fifth, invoked her Fifth Amendment right against self-incrimination. Not yet, Your Honor. Well then, Mr. Kirshner, the issue isn't ripe. It's not ready for me to decide it. Go back, present her to the grand jury, and see what she does. That's a real-world example, friends, of how an issue is not ripe until it's ripe. Because you know what happens? Often I would have witnesses tell me, I don't want to testify, I'm going to plead the Fifth. But it really wasn't because their testimony would incriminate them. It was because it would incriminate their boyfriend, or their girlfriend, or their spouse, or their neighbor, or somebody they were scared of, or somebody that they were trying to protect. So they would use the Fifth, they would throw it up as an obstacle, as an attempt not to have to testify because they just didn't want to testify for any number of reasons. So what would happen is sometimes I would put that kind of a witness in the grand jury. They realized I called their bluff, and they would throw up their hands and they wouldn't invoke the Fifth, and they would go ahead and testify. And that demonstrates or illustrates how the issue ain't ripe until it's ripe, until the witness goes into the grand jury and the prosecutor asks that witness all the questions. Maybe it's 100 questions, maybe it's 1,000 questions, it might be 5 hours worth of testimony, but you have to ask all the questions. You have to let the witness invoke whatever privilege they're going to invoke. Maybe it's the Fifth Amendment privilege against self-incrimination. Maybe it's the attorney-client privilege. Maybe it's the doctor-patient privilege. Maybe it's the executive privilege. Maybe it's speech or debate clause privilege, which Mike Pence doesn't have, but he might try to pull that one out of his sleeve. We'll go with sleeve there. And only after you develop all of that evidence on the record can you then go to the judge and say, now, Judge, we want you to assess this and we want you to rule that these privileges are bogus. Mike Pence can't invoke them, and we want you to order him to testify. That is the way the issue is ripe. That is the way the issue gets resolved by a judge. But that is not what Jack Smith is doing, friends. That's what pretty much every other federal prosecutor who's been involved in, investigating the crimes of Donald Trump and his criminal associates have been doing, because that's the way federal prosecutors usually do it. Put Mike Pence in the grand jury, ask him 5 hours or 10 hours or 2 days worth of questions, because he's not going to have a privilege to all of them. For example, did you ever talk with Ginny Thomas? Did you ever talk with Scott Perry, Kevin McCarthy? Well, those kind of questions have no privilege, not an executive privilege, because he wasn't talking with Donald Trump, which is where the executive privilege comes in, and he wasn't talking to his lawyer, so it's not attorney-client privilege, and he's not presumably incriminating himself if he's talking to Kevin McCarthy or Scott Perry. Those men may be incriminating themselves, but that doesn't give Mike Pence a right to plead the fifth. But it's only after you've asked all those questions in the grand jury and developed that record that the issue is ripe to be resolved by the judge. But that takes forever. Because first of all, you got to get Mike Pence into the grand jury. You got to wear him out, ask him thousands of questions, develop the record, brief it all up for the judge, set an oral argument schedule, go in and argue it, wait for the judge's decision, and all the while the clock is ticking down. We're burning democracy daylight. Mike Pence is delaying and weaponizing that delay to his advantage and Donald Trump's advantage as our democracy continues to die. And that's not what Jack Smith chose to do, but it is what most prosecutors would have done. Jack Smith said, not this time. This is too important. It's too urgent. It's too time sensitive. So before I ever try to drag Mike Pence into the grand jury by the scruff of the collar, I'm going right to the chief judge. And I want the chief judge to decide if there's enough of a record right now for her to order Mike Pence to testify. This is a preemptive move by Jack Smith. This is an offensive move by Jack Smith. This is Jack Smith going hard and going fast, going scorched earth in the direction of accountability. No two ways about it. And friends, maybe it will succeed and maybe it will fail. Maybe Judge Beryl Howell will say, no, I think you need to put him in the grand jury and follow the normal, slow, time-consuming process. Jack Smith is not satisfied by following the same old blueprint. You know why? The same old blueprint has never been applied to a criminal president who tried to overthrow our democracy and a vice president who is trying to hide, bury, secrete the evidence of Donald Trump's crimes that he, Mike Pence, has. Mike Pence is the smallest, most scared, most unpatriotic man in America right now, unwilling to tell the grand jury, just like he was unwilling to tell the January 6th committee about the crimes of Donald Trump that were designed, that were committed in an attempt to kill our democracy. Mike Pence. And Jack Smith is having none of it. So friends, when I say that Jack Smith is like a baseball pitcher striking out people in the dugout or trying his level best to do so, that is precisely what he's doing. And we have, I believe, and I hope we're not being fooled, but I don't think we are, we have a special kind of justice warrior in Jack Smith. And I know people who've worked directly for him, and that's what they tell me their take is, their experience is, their belief is. And it's an informed belief. So I know justice has taken forever. I know sometimes we can't see accountability anywhere on the horizon, but friends, it feels to me, it really does, like with the 1-2 justice punch of District Attorney Fani Willis on the eve virtually of indicting Donald Trump and his criminal associates, and Jack Smith doing what few federal prosecutors would do, not going by the tired old blueprint, because no one has ever had to draw up a blueprint for a criminal president trying to, attack the Capitol, stop his political opponent's win, and unconstitutionally retain the power of the presidency. That calls for a new approach. You don't just follow the same old blueprint. So with the 1-2 justice punch of Fani Willis and Jack Smith, I wish I could say it was a 3-punch combination and put Alvin Bragg in the mix, but I don't think we're there yet. And I don't think Alvin Bragg has even given anybody a light slap, never mind a good justice punch. Talking figuratively, not literally, not violence. But I'm not prepared to say we've got a 3-punch combination working at this point, but we've got a 1-2 justice punch. And I am feeling better today about the prospects of Donald Trump and his criminal associates being held accountable than I have felt in a very long time. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.